Good afternoon or morning, whatever the case may be, whenever you're watching this. My name is Darrell Spinks. I'm the Executive Director for the Texas Behavioral Health Executive Council, one of the newest state agencies here in Texas. And I've been asked to visit with everyone for about 30 minutes today. That seems to be about the extent that anybody wants to listen to a lawyer nowadays. So I'll try to keep it brief and not geek out on you too much in the next 30 minutes. But I've been asked to talk to you today, kind of give a state of the state update on both this new agency, what we call BHEC, the Texas Behavioral Health Executive Council, and kind of the state of mental health regulation here in the state of Texas. So with that, what are we going to be talking about here today when we're in this state of the state? Number one, because it's a new agency, I want to visit with you about what the council is and what does it do, because I know there's going to be a lot of people that some of you may have never heard of BHEC. You may have only heard of the regulatory board that's actually issued your license, whether it be the LPC board, the social work board, marriage and family therapy, whatever the case is. And then some of you just will never have heard of BHEC, or you don't know why the council has taken over the regulatory functions of the board that originally issued your license. We're also going to be talking about some significant rule changes that the council has enacted, or just issues that are pending before the council that I think probably everybody would be interested in knowing, or at least you should know about. And then lastly, I want to visit with you about some of the significant or the important bills that are pending in the 87th legislature, and kind of talk to you about where the legislature is. As we're making this video, the legislature is well into its 87th session, so that'll kind of give us some insight, or hopefully I can kind of give you some insight into what's going on over there. And by the time you watch this, it probably won't have gavelled out, so you'll still have the opportunity to maybe influence some legislation if I pique your interest on something. So with that, let's get started. So what is BHEC and what does it do? I'm going to call it BHEC throughout this presentation because the full name is such a mouthful. But BHEC is actually an umbrella agency that was created by the 86th legislature. Now, it arose out of two consecutive sunset reviews of the member boards, and those sunset reviews took place in 2017 and 2019. And if you don't know what a sunset review is, every regulatory agency in Texas has a built-in death clock, if you will, in their enabling legislation. In other words, if you look at the statutes that create the LPC board or the social work board, you will see in those statutes that those boards go away. They die if they are not continued by a date certain in that statute. And so at the end of that date certain, the Sunset Commission, which is a legislative agency in the state, they review the agencies to determine, are they carrying out their mission in an effective and efficient format? And so what happened was, beginning in 2017, the Texas State Board of Examiners of Marriage and Family Therapists, the Texas State Board of Examiners of Professional Counselors, the Texas State Board of Examiners of Psychologists, and the Texas State Board of Social Worker Examiners all underwent sunset review. Now, it's important to keep in mind that at the time they underwent that review, the LPC board, the MFT board, and the social work board were all administratively attached to the Health and Human Services Commission, HHSC. For those of you that are licensed with those boards, you'll remember you went to a different website than what you go to now to renew your license or to submit questions. Whereas if you're licensed under the psychology board, you went to TSBEP's website back then to do that. So each of you were regulated by different boards, but those of you that were at HHSC, you were what we call administratively attached, which means you didn't have your own staff, you didn't have an ED like me, you didn't have a general counsel. All of that was provided by HHSC. That's an important thing to know in a minute when we talk about why BHEC came to be. By the way, I'll just confess right now as we go through these slides, you're going to see that I do not adhere to any of the rules anybody has ever taught you about how to do a PowerPoint presentation. Most people will tell you only put 2 or 3 points on that. I think that's a bunch of hogwash, because I know you're just like me. Whenever I sit in continuing education courses, you're zoning out thinking about what you're going to do on the weekend or when you get home. So what I've tried to do is design these slides with enough information in each slide. If you have to go back, you actually have a little more meat than just 1 or 2 bullet points to draw from and kind of expand your search from. I'm trying to give you better search terms than just 1 or 2 points in it. So forgive me if it's not the standard format you're used to in a PowerPoint. I don't do things the way other people do on the PowerPoints, which makes them a little longer. But before we get into those boards again, let's talk about what the mission of the council is. I'll just tell y'all right now, the council's mission really isn't any different than what the original board that issued your license, if you're a licensee out there watching. The basic premise of all state agencies is to promote and protect the public welfare of the state. In other words, we are designed to make sure that the public is not harmed and that they are protected from unqualified and unscrupulous practitioners of whatever the regulated profession is, whether it be lawyers like myself or counselors and social workers and psychologists like those of you out in the audience today. That is the basic underlying premise of what regulatory law in the state is about. Now that gets tempered by a bunch of other laws that are out there at both the state and federal level, and we'll kind of touch upon that here today, but that's a pretty in-depth discussion that we really won't have time to talk about in this 30-minute session. Where is that mission derived from? Very simply from what we call the enabling legislation, or the underlying statutory authority that creates the council, that creates the LPC board, that creates the psychology board. You have to look to those statutes and determine what the legislative intent is. In other words, the legislative intent is pretty simple. It's so that our job is to keep unqualified and unscrupulous practitioners from getting into the profession, and if someone turns into an unscrupulous or an unqualified, they lose the ability to deliver competent and qualified services. It's our job to sanction them or to remove them from the clubhouse, if you will. So that's kind of the mission of BHEC in a very general manner. How does it accomplish that mission? We really do it in three different ways. There's three different things that almost all occupational or regulatory agencies do. When you boil it down, we have a licensing division, a licensing function. We have an enforcement function. Think of it as the police or the mental health care worker police force. And then we also provide information. On the licensing, like I've already said, each of the boards, they set the criteria that you have to meet in order to receive a license to practice whatever the discipline is, whether it's marriage and family therapy, psychology, or social work. And then those boards also set what the punishment is, or what the standard of care and what the punishment is if somebody breaches one of those standards. So, for example, on the LPC board, and the only reason this comes to mind is because I dealt with an issue this morning. There was an individual who had emailed me wanting to know why she had to comply with the statutory requirement, or the requirement that she have 3,000 hours of supervised experience in order to be an LPC. And I'm like, it's very simple, because that's what the legislature has said you have to have. And so the board has rules that enforce what that legislative mandate is, and we cannot waive or exempt those. And the legislature has set that for a reason, because they feel like in their collective wisdom that 3,000 hours is the amount of experience it takes in order to be a competent practitioner. You got to remember that both the legislature and the board, they're setting licensing criteria to give you a piece of paper to go out and play in people's heads. People who may be suicidal, who may be going through extremely difficult times in their marriage or with their family or in a court proceeding. And so we don't want unqualified or halfway qualified people in those professions, because a lot of bad things can befall people. So that's one of the ways we accomplish our mission, is by making sure that only those qualified people get in. Now, a second function we do is the enforcement side. This is usually the more, for lack of better words in the vernacular, this is more the sexy side, what more people are interested in, I think, whenever we give presentations. I know with lawyers that you always flip to the back of the bar journal to see who got disciplined in the latest bar journal that comes out, and I feel like probably these professions are very similar to that. Everybody's always interested in who did what and what happened to them. The enforcement side is very simpler. We have a complaint-driven system, so that if you're providing services and you breach a standard of care, or you do something you shouldn't do, and somebody complains on you, the board investigates that. Then if we find that, or the council investigates that, if we find that you breach that protocol or that standard of care, then you're going to be sanctioned according to the standards set by whatever your respective board is. And then the third way in which we accomplish our mission is by providing information. One of the things Texas was actually first in this, I believe, and one of the things we've always had taken a pretty stout stance on is transparency and openness in government. We have an Open Meetings Act that kind of comports with this area as well, but we also have a Public Information Act that almost everything in an agency's possession, documents, information, is presumed to be publicly available. There are some exceptions. Certain complaint information cannot be shared or disclosed to the public. But one of the primary ways that we help protect the public is simply by providing information. And here's a real-world example of how that works. Let's say somebody gets licensed and then they have an inappropriate relationship with a patient. And the board and the counsel say, okay, Dr. X, because you had an inappropriate relationship with young men in your practice, you are now forbidden from treating minors under the age of 18, and we enter that into a disciplinary order, so Dr. X from that point forward can only treat adult patients. That order becomes public, so that if anybody is thinking about taking their son, or they're not a minor, say they just became an adult under the law, they can look that information up on our website and decide for themselves, do I want to go receive services from this individual when he did not respect the boundary issues that have been set by the profession. That's all very important information for the public to have. It's their heart and soul that is coming out in the sessions and in the services that you guys provide to them. So it's very important that the public have access to that type of information so they can make an informed decision. I don't want to oversimplify it by saying it's like you being able to look at everything before you buy a car or anything like that, but it's consumer information, if you will, and I don't mean to cheapen it by using that word, but that's kind of the best way to describe it. That's one of the ways we protect the public, is by making everything open. Now, there are certain things that we cannot disclose, Social Security numbers, things like that about you guys, but if somebody wants to write in and they want to request the professional file, which is the application file for any one of you who are licensed with us, they can do so, and that is public information. We have to provide that. We just redact the confidential information out of it so they can see what kind of education and training you have. So why was the council established to carry out these missions? Because all the boards were basically doing this same thing whenever they were individual boards. So why was the council created? The council was created for two primary reasons. For those of you that have been licensed or were licensees while the marriage and family therapy, the counseling, and the social work boards were at HHSC, you know all too well the difficulties that those boards had while they were administratively attached. Part of the problem with administrative attachment is the boards themselves have no control over the staff. In other words, the staff actually work for HHSC. HHSC gets to dictate what level of manpower is assigned to those boards, and that was part of the problem. We had boards whose manpower demands far exceeded the manpower availability provided by HHSC. And I don't mean to demean HHSC whenever I say that. We live in a world of limited resources, and we have to operate within that world. We're probably never going to have the level of resources we need in order to operate at peak performance. That's just the reality of the situation. But we have to do the best with what we can. And what the legislature and the Sunset Commission found is they did not feel like that HHSC was able to deliver the level of manpower and assistance that is needed for those boards to operate efficiently. Whereas the psychology board, and I was the executive director for the psychology board at the time, the psychology board actually had a very good report from the Sunset Commission. We had a very efficient and streamlined operation. And so the Sunset Commission looked at it and said, well, if we can do this, if the psychology board as an independent agency can do this, and we can duplicate those results for these other boards, why don't we create one big umbrella agency, put them all under it, and then see if we can duplicate what the psychology board has done for all the boards involved. So that's probably the primary driving reason why we have the council today. Now, there are some caveats to that when I say they're grouped under the umbrella, and we'll talk about a little bit more about that in just a minute, but that's the primary reason why we have the council. Now, a secondary reason, and one that those of us from the psychology board testified heavily and pushed heavily for during the sunset process, was I think it was 2012, 2013, the North Carolina Dental Board got into some trouble with the Federal Trade Commission. To make a very long story short, that lawsuit that resulted between the North Carolina Dental Board and the Federal Trade Commission resulted in a watershed change in administrative law across the country. What agencies up until that time had enjoyed what we call active state immunity. from any kind of federal antitrust law proceedings. In other words, the government, the federal government, the Federal Trade Commission in particular, could not come in and sue a state agency for engaging in monopolistic or anti-competitive conduct because we had active state immunity. Think of it in terms of sovereign immunity. With the North Carolina Dental Board case, the Supreme Court said, no, you don't get that anymore. We're doing away with that principle if your board is made up of a controlling number of market participants. Now, what that means is if your board has a controlling number of licensed professionals whom that board regulates, then you have to have active state supervision. In other words, supervision by somebody who is not controlled by a controlling number of market participants before we will allow that agency to retain its active state immunity, or its state action immunity, excuse me. Long story short, none of the boards, psychology, MFT, none of them, or excuse me, all of them had a controlling number of market participants on their board. None of us enjoyed the state action immunity that we had enjoyed up until that time for decades and decades. Like I said, it was a watershed change. And what that meant was that now the state, and in some cases even the individual board members and myself, were subject to individual, or could be subject to individual liability for any kind of antitrust action that was brought against the state. I can assure you that if you've ever considered throwing your hat in the ring to sit on one of these boards, never once did it run across, or never once did you ever consider, gosh, would I be personally liable for actions taken by the state? None of us signed up for that, and I can assure you that if you are contemplating running for a board position, that's not something that you've probably ever contemplated or would sign up for. So the Sunset Commission and the 86th legislature realized this, and they thought, well, this umbrella agency, the Executive Council, will be a good way to provide that active state supervision so that our individual board members are not liable for any kind of conduct that the state may get sued for, any kind of anti-competitive conduct. So that's another big reason why we have the council here. I've provided here for you an overview, an organizational chart of the council, just to show you how many staff we have. Currently we have 64 what we call FTE positions. That's 64 positions for people in the agency. I think we're sitting at 50-something, 58, 59 actual warm bodies employed by the agency right now. I've got 4 or 5 vacancies that we're looking to fill. Most of them are in the enforcement division. I've got a couple that are over in licensing, I believe. But for the most part, we are staffed out and working. Now, one thing I'll point out for those of you that are aware of the backlog that came over from HHSC on the licensing side for social workers and LPCs, I will tell you, when the LPC program came over to the council, there was one person assigned to that council, or assigned to that program. That program receives 7,000 or 8,000 applications a year. One person cannot do that. The social work program had 5 people assigned to it, 4 or 5, I can't remember. We currently have 5 people assigned to it, with I think 1 more in the making. Now, I have requested additional staff during this legislative session to address the backlog so that we can add to those ranks and process, because social workers, much like LPCs, receive 6,000 or 7,000 applications a year. That may not sound like much to you, but I can assure you that is a lot of applications to process. And it's particularly a lot whenever you're doing it on a paper-based system, which we're trying to move away from. We've actually moved away from that on the LPC side, and we're working towards it on the social work side. But just to give you some idea of how that staffing is broken down, I've put in this organizational chart for you. So what are some of the significant rule changes rule changes and issues that are currently pending before the council? If you went through the licensing process while it was at HHSC, or you went through the licensing process at TSBEP, the Psychology Board, you're going to notice a pretty significant change in that process. One, because we are now processing applications for 4 different professions, we had to get adaptive in how we handle problems or issues that come up with applications. The way it was handled at HHSC, it was difficult to be efficient, is I guess the polite way to say it. What we have done is we have removed a lot of the board involvement in deciding application issues and shifted that responsibility to the staff, which is candidly where it needs to be if you're going to do this quickly and efficiently. And how we have handled the issue, let's say an issue comes up with your criminal history. You've applied and you've got a felony level drug possession charge on your background. That per se is not going to keep you out of the profession. How it would have been handled before is it would have automatically gone to the board. Now staff are going to look at it. We've revised the rules to give staff more clarity as to what is an acceptable versus non-acceptable criminal history. The same goes for other areas. We're trying to revise the rules so that they provide clear guidance to staff so that we don't have to go to the board for all these issues, so that the staff can make the decision on a much faster basis at our level. However, if we do hit a problem, what you see here on the screen is the application review chain. That's the review process that it goes through if we hit something and staff aren't comfortable with making the call. That's the process it goes through. Now, one thing I want to point out, and that needs to be clear, is that process is for staff's resolution of a problem. The applicant doesn't get to say, well, I want it to go to the licensing manager, or I want it to go to the ED. That's not how it works, because if that were the case, everybody would just jump straight from staff up to the full member board, and we'd be right back to where we were, because inherently when people hear what they don't want to hear, they automatically want to appeal it. And those types of I want to just jump ahead and appeal to whoever the ultimate, who has the final say, is an extremely inefficient way to run an agency. It really slows things down. It would put us right back to where we were when y'all were over at HHSC. So we're not going to do that. That chain of review is for staff. It just shows you it's in rule, it just shows you what the review process will be. That's one big change that I wanted everybody to know about. There are a couple other changes that everybody is going to feel, except for maybe the folks in psychology. One, if you're an applicant for any of the boards, you're going to have to undergo a fingerprint criminal history background check. That's been the case for several years now for folks applying for a psychology license. That's a new requirement for marriage and family therapy, social work, and professional counseling. Y'all were not undergoing fingerprint criminal history background checks. You were undergoing name-based criminal history background checks. And here's the difference. When we run you through a fingerprint-based background check, you go get a digital fingerprint taken. That enrolls you in what is called a wrap-back system. You never again will have to go get another background check for us, because if you do anything in the United States or a protectorate or territory of the United States, it's going to show up in the FBI database and trickle its way down to us. So once you've had a background check, for example, and let's say you go to the wine festival in Lexington, Virginia, and you get in trouble out there, you get a DWI, we're going to know about it before you ever get back to Texas. Now, I'm not saying we're going to do anything about it, or that's going to prohibit you from getting licensed. I don't want anybody freaking out and extending what I just said to some unreasonable degree. But you just need to understand that if you've done anything anywhere in the country, this is not just a DPS fingerprint background check we're making you undergo. It's going to show up any offense anywhere in the U.S. or a territory or protectorate. Puerto Rico, Guam, all those types of things. Anybody that reports to the national or the federal database, we're going to see. The other thing, another new thing that applicants are having to do is to submit a self-query report through the National Practitioner Data Bank. That's that NPDB acronym. And what that database is it's a federal database that all state agencies are required to report to. It will tell us if you have had a license in another jurisdiction and got in trouble, if you've ever been sued for malpractice, if you've ever had any kind of insurance fraud allegations brought about by Medicare, Medicaid. All of that stuff is consolidated into the NPDB, and we can see that. One good thing about that is that's eventually going to negate the need for applicants to provide so many verifications of licensure. Historically, we would always ask applicants to provide us with verifications of licensure in every jurisdiction that they've been in. We're now going to start moving away from that, because The only purpose of that was we wanted to see, did you get in trouble in that jurisdiction? I really don't care so much if you've been licensed in Virginia, Montana, and Idaho. It's just the thing we were interested in the past is, did you get in trouble there? Well, the NPDB is one-stop shopping for that. Whereas you might have to pay $50 for each of those jurisdictions to get verification sent to us, now you have to pay $4 to the NPDB, and they send you a report that covers the entire U.S. So eventually we're going to try and get to where we run that on you from our office, and you don't have to submit a self-query report. We're just not there yet, but we're slowly working there. But anyway, for those of you who haven't applied yet and that will have to apply in the future, the NPDB is a new change. Now let me back up on the fingerprinting. I will just say, if you're a current licensee of the council, you're going to have to undergo a fingerprint background check the next time you renew your license, unless you have already undergone one for us. What does that translate into? Unless you were licensed with the Psychology Board, you're going to have to go get a fingerprint background check, so just get ready. You will get the instructions on how to download that fingerprint information on your renewal postcard. So make sure that your address is correct in our database. Go into the online licensing system, make sure that you've got the current address, your current address in that system, so that we get the renewal reminder to you at the correct address. I also send out on each month an email to everybody for whom we have an email address with this same information that's on your renewal postcard. I'm going to tell y'all right now, if you don't get the postcard and you don't get the email, that doesn't negate you from the responsibility of undergoing the fingerprint background check or renewing on time. We're not going to cut you any slack. We're not going to waive any late fees. Your license will become delinquent. So it's incumbent upon you to make sure that your address is correct, and so that we can send you the renewal reminder. Now the last thing is for applicants, or the last new application requirement for applicants I want to talk about is the verification requirement through the SAVE system. There is a federal law that basically says you can't give a professional license or an occupational license to anybody unless they're a lawful resident in the U.S. And so if you check on the application that you're not a U.S. citizen, then we're going to run you through that SAVE program. It doesn't cost the applicant anything, and it's pretty simple information that we need. If you're here lawfully, you'll have all that information at hand. And we've run, I think we've run 4 or 5 a month, not a lot, but it's a very simple process. It takes about 2 seconds to do. The feds get it back to us very quickly, but it has not been a problem. Everybody that we've run through it has been here lawfully so far. We haven't had any issues. I haven't had to deny licensure to anybody who was here illegally, so that's a good thing. Another thing that, another big change that we're doing is we're accepting examination results from credential banks that use primary source verification. And we've already talked about the fingerprinting requirement for renewals, license renewals, so I'm not going to go over that again. The next area that I want to visit with you about where there's a significant difference is in the enforcement process. The way complaints were handled at the MFT board, the LPC board, and the social work board is very different from how complaints are handled now under the council. The council uses a system that is very similar to what the psychology board used, except we've streamlined it even further. And by way of example, now here at the council, the executive director, myself, I have the ability to dismiss complaints and sign agreed orders without having those approved by either the council or the underlying board. Now there are some limitations on that I don't have time to go into here today. But the big differences I want to talk to you about are, if it's a complaint that doesn't require the use of expert testimony over at the State Office of Administrative Hearings, then we can conduct ISCs at the staff level. What that means is we can conduct ISCs very quickly and on an ad hoc basis. We don't have to wait until a board meeting. We don't have to wait and schedule an ISC with board members. We can just set it up via conference call, via Zoom call, or in person. It really helps speed up the process. However, if it's a complaint that that requires expert testimony in order for me to prove, for example, a child custody complaint where the individual is alleging you didn't have a substantial basis to support your opinion, that type of a complaint requires expert testimony in order for me to prove a violation at SOA. In those instances, an informal settlement conference would have to be held with board members present. That's a big difference. That's a very big departure from the way complaints were handled over at HHSC, and candidly, it's a departure from how things were handled at the Psychology Board. But I will tell you, just from what I have seen thus far, it is actually working out very well. It has really helped speed up the process. So those are two big areas in the complaint process I wanted to visit with you about. A couple of other big rule changes, and I'm not going to go into great detail. You can read about it on the screen here. We've had to create, I don't want to say there are new evidentiary requirements or initial requirements for anybody filing a complaint involving a custody or a court-ordered evaluation. Those complaints are extremely resource intensive to investigate, lots and lots of reading. They take a lot of time. There was one in our office the other day. It was over 800 pages of reading. You can imagine when you have dozens of those types of complaints, the amount of man hours that have to go into reviewing and investigating them. And candidly speaking, from the statistics, most are dismissed as being unsubstantiated. So we have tried to put in place criteria to sort the meritorious complaints from the unmeritorious complaints. And so that was a big rule change. Moving on, let's see here. One other significant issue that has been pending before the board, if you've paid any attention to what's going on at the social work board, back in the last part of 2020, we had the issue about whether or not language concerning gender, disability, sexual orientation, gender identity and expression, whether or not we had statutory authority to include that in the existing rules. Now, currently that language is still in the rules. It was never removed, but we've got an opinion request with General Paxton's office to determine whether or not the council and the board actually has statutory authority for that, to include those words in it. There's a question of whether or not the board and the council has that authority. We're still awaiting that opinion. Candidly, I don't look for that opinion to come down until after the 87th legislature has gavelled out, because I think probably the Attorney General wants to give the legislature an opportunity to correct that problem if they see fit. But that's just Darrell talking. I haven't talked to anybody. I don't have any reason to, that's just what I think. So don't read too much into that as I know something you don't, because I don't. That's just, I'm going off my gut instinct there. The next issue that I want to talk to you about is kind of the third topic in our series of topics here, is just kind of some important bills that are going on over at the 87th legislature. It is now March 23rd on the date that I'm recording this. I think you all will be watching it sometime in April, if I recall correctly. So the bill filing deadline was March 12th, so no more bills can be filed at the Texas legislature for the 87th legislature. If there's whatever has been filed, that's all that's going to be filed. Currently, I'm tracking at, it shows 84 on the screen, but I can tell you at the time I put this together, it was 84. It's since grown to a little over 100 bills that I'm currently tracking. The big issues that I see affecting the profession, and I'll just tell you, there aren't a lot of issues that affect the agency directly. In other words, there's not any bills filed that would affect the structure or operation of the agency per se. Most of the bills that I'm going to talk about here, or that I'm touching upon here, really affect your profession more than they do the agency. It's just going to be things that if they pass, we'll have to make sure that you guys are complying with. We'll enforce them, but they don't require any changes to the agency itself. And the first one is there's a lot of bills filed that ban conversion therapy. I'm curious to watch those bills because there's some federal litigation out there that kind of goes both ways. There's a case out of the Ninth Circuit, I think it's called Pickup, and I can't remember the full case name, Pickup, that basically the Ninth Circuit has upheld California's ban on conversion therapy. California calls it something else, and I can't remember off the top of my head what that is. And then there's a case out of the 11th Circuit, which is Florida, where some marriage and family therapists challenged the city of Boca Raton's ban on conversion therapy and actually prevailed in their litigation. That litigation is not final, but they prevailed in a temporary injunction against the city of Boca Raton, and the 11th Circuit said, yeah, you can't ban conversion therapy because that's protected speech under the First Amendment. So you've got competing case law out there, which that's what makes it ripe for Supreme Court review. Just because it's ripe doesn't mean the SCOTUS will take it up, though. But anyway, I'm watching those bills, especially in light of the two competing federal circuits. The Fifth Circuit has not, which is what Texas is in, the Fifth Circuit has not come down one way or the other on that issue. Preferably I would like to stay out of the law books and let's let the Ninth or the 11th Circuit figure that out. Another set of bills that I'm looking at that would definitely, I know all you are going to be interested in, is parity between in-person and telehealth services. In other words, insurance companies right now aren't paying folks who deliver telehealth services the same as they would if the services were delivered in person. I'll just tell y'all, I mean, that doesn't make a lot of sense to me why they're not doing that, because one of the things that the pandemic has taught us is that the delivery of services to telehealth is a very effective way. There's not a lot of drawbacks that I can see. From my perspective as the ED, I'm not seeing a lot of drawbacks from it. I'm not seeing a spike in complaints arising out of telehealth. From what I can tell, it's working, and it's working pretty well. So I'm not sure where those bills are going to go, but I hope they go. I can't lobby, but I hope they go I hope they go the distance. I got to quit stepping on that pedal. I'm messing up my presentation here. The next group of bills that I'm tracking deal with governmental bodies meeting via conference call or video conferencing. All of the agencies are hoping and praying that some bill in this category passes. The way the Open Meetings Act works is we have to meet in person and we have to be in a room where you guys can come in and watch us. And the reason being is you don't want board members and council members passing notes under the table and kicking each other in the leg going, don't vote for that. You want everything above board and in the light of day. But when you have things like the pandemic, you also need to be able to have things virtually. And the governor had suspended certain portions of the Meeting Act early on in the coronavirus pandemic, and that has allowed the council and all its member boards to conduct 100% virtual meetings. It's worked out very, very well, way better than what I ever thought it would have. It's actually increased the participation in all of our meetings by a large margin. Just to give you an example, typically you would have anywhere from 6 to 20 people attend a board or a council meeting pre-COVID. It is, I don't think I've seen anything less than 35 or 40 at a board meeting now. And then we have had upwards of we've had the max of 500, which is all my Zoom subscription will allow on it. We've maxed that out on at least one meeting. So the level of public participation we have received is just incredible. I would rather keep that, but we need a bill, we need the change in the law that will allow us to keep 100% virtual meetings. If we don't have that, I have to go back to bringing the presiding chair or member of whatever the board or council is that's meeting. I have to bring them into the office, and I have to set up an office that's open to the public. And then I would still like to broadcast that meeting virtually, but it's just kind of a pain, and it seems ridiculous to have to open up a room where probably nobody's going to come to, because you can still sit in your home or office and watch and still give public comment just as though you were there. So it doesn't make a lot of sense. The law is going to be antiquated in this post-COVID world. So I'm really hoping that that bill gets passed so that we can kind of move forward with this. And the last group, the last group of bills I want to talk about is there's a lot of bills that are addressing discrimination against the LGBTQ population. The reason I've been watching that is because of the issue that arose out of the social work rule change. I'm watching those bills in particular. None of them seem to really address the issue that was before the board or the council, but you never can tell what's going to get put into a bill at a last minute as an amendment, so I'm kind of tracking those bills along those lines. So those are the big things that the council, or that I'm tracking for the council. If any of you would like a copy, or if you would like to see the full list of bills that I'm tracking, if you will just email me at that general@bhac.texas.gov email address that you see on your screen there, put that subject line in it, I will actually shoot you the list of bills that I'm tracking. It'll show you where they are, whether they're in committee, whether there's been a hearing. It'll tell you where they are at in the legislative process so that you kind of know. Because there are some dates by which, if bills don't clear certain dates, that you know that bill is effectively dead and it's not going anywhere. And some of those dates are fast approaching. So If you're interested, shoot me that. By the time you're watching this, it'll almost be a done deal as to what's going to pass and what's not. You ought to be able to determine with much more certainty what's going to become law and what's not by the time you're watching this, if you get a copy of that tracking bill that I've got up there. So with that, I would like to thank you guys for inviting me over. I hope this has been somewhat helpful to you. If it's not, I apologize. I'll try to do better if I'm invited back. But if you have any questions, you have any concerns, feel free to reach out to me at that email address. Just go to the Contact Us webpage on BHEC's website. You can find it there. And that email actually comes to me. I'd usually respond to it within a day, usually within a matter of hours, so it doesn't go to somebody else, it comes to me. But I'll try to get back to you. I try to answer any questions, and I appreciate your time and attention, and hope to visit with you again someday. Thank you.